hearings of NMP 6045, application of Westman JLC Solar LLC for a certificate of public good pursuant to 30 VSA section 219A and 248 and board rule 5.100 for a 500 kilowatt group net metered photovoltaic electric generation facility in Cambridge, Vermont, and CPG NMP 6046, application of Cambridge GLC Solar LLC for a certificate of public good pursuant to 30 VSA sections 219A, 248, and board rule 5.100 for a 500 kilowatt group net metered photovoltaic electric generation facility in Cambridge, Vermont. My name is John Gerhard, and I am the hearing officer today. If I could ask the parties to enter their appearances, I would appreciate it.
Jeannie Elias, counsel for the Department of Public Service, and with me today is the department's aesthetic expert, Mark King.
Roxanne Martin, motion to intervene.
Mm-hmm. Okay.
David Carpenter from Kinlan, Schweber, Facey, and Goss, counsel for the applicant. With us is technical expert Jeremy Owens from TJ Boyle and Principal Luke Schomberg of Cleveland.
Okay, excellent. Before we went on the record, we talked about a number of things, but one thing that we did not talk about, and I just want to highlight at this point for the parties, is I'd like to just remind everybody that the hearing is specifically on the aesthetics criterion. And so I'm going to ask the parties and the witnesses to attempt to stay on focus and not wander into other areas that don't deal with the aesthetics criterion, because what the board has charged me to do is collect and compile more evidence on aesthetics. And in particular, in the order, there were 4 questions that the board is interested in securing some more information on. And I'm going to read them quickly now. What are the characteristics of the views of the projects along Westman Road, Upper Pleasant Valley Road, Lower Pleasant Valley Road, and Irish Settlement Road? Number 2, whether 2 500 kilowatt solar projects will be dominant or highly noticeable elements in a landscape that is otherwise characterized as rural and agriculture. Number 3, whether the petitioner's consultant considered the cumulative effect on aesthetics of the 2 projects taken together. And 4, whether vegetative screening can successfully mitigate any adverse effects. So, not to belabor the point, but to repeat myself, let's try and stay focused on those particular issues.
Can you repeat that once more, please?
Certainly can. What are the characteristics of the views of the projects along Westman Road, Upper Pleasant Valley Road, Lower Pleasant Valley Road, and Irish Settlement Road? Number 2, whether 2 500 kilowatt solar projects will be dominant or highly noticeable elements in a landscape that is otherwise characterized as rural and agricultural. Let me know when you caught up, Ms. Martin.
Okay.
You ready?
Yep.
Number 3, whether the petitioner's consultant considered the cumulative effect on aesthetics of the 2 projects taken together. And whether vegetative screening can successfully mitigate any adverse effects. Okay. Also, before we went on the record, we spoke a little bit about 2 outstanding motions. One was a motion by the petitioner, I don't know if it was a motion or if it was a motion, an objection, I guess is what I'm looking for, to Ms. Martin filing her comments late, and as that's something that the board has already ruled on, there's no need for me to rule on it today. Additionally, there was an objection to using the cumulative impact standard for the aesthetics analysis. And once again, that's the standard that the board has asked me to apply in this hearing, and so there's no action that I can take on that objection. I just wanted to note for the record that both of those objections have been addressed. Okay, yes, ma'am?
May we go off the record to discuss one other matter?
Certainly can.
I'm not sure if the parties filed their discovery with the board.
We did.
I suspect that Mr. Carpenter did. I don't know if Ms. Martin did.
I think, I just sent a copy to you, not to the.
Did you email it to the board?
No.
Yeah,
to Jerome.
I will say I was not aware that there was any discovery other than what has actually been emailed to the board, and I got copies of, I believe it was answers from the petitioner. I didn't receive any other.
So there was additional discovery that was propounded on Ms. Martin by Mr. Carpenter.
We made a set of discovery demands on Ms. Martin.
And we.
Those I received. I never received any answers from.
Okay.
Right, so with respect to the answers, I had a sense that the board never was copied, and that probably should be corrected, because normally the board receives copies even if we don't have them here today, and I don't know if we're gonna refer to them today. But one of the confusing things about the copy of those discovery answers that the department got from Ms. Martin is that they're mislabeled. They say applicants' responses to the Department of Public Services discovery requests.
Okay.
We did not file discovery requests.
Okay.
And the applicant didn't make answers. So if those answers do get filed, the title of them needs to say Roxanne Martin's answers to the applicant Westman and Cambridge's discovery request. So I had a feeling, I think Ms. Martin called me and asked me should she email her discovery answers, and I wasn't able to reply, but I didn't know that she hadn't filed them with the board, because I had no way to know that
Okay.
until we asked that, we had asked and answered that question today. So normally Ms. Martin discovery response is one copy only, gets filed with the board, filed by paper for sure.
Okay.
Electronic copies are nice, and we all agreed to do that in this instance. But what also needs to happen is that there needs to be a correction on the cover page of your discovery responses, because
Okay.
it's got the wrong parties listed.
Okay.
And this is a question that will bespeak my continuing befuddlement with the board's rules. Those aren't entered, you're not suggesting that to enter those into evidence, are you?
A party could use them in cross-examination.
Yeah,
But they're not in the record.
They don't become part of the record.
Yeah.
'Cause
They're not part of the evidentiary record of the hearing, they're part of the public file for this docket.
And I get that,
Yeah.
but
So,
I just basically, what I need to know is whether I need to put in a standing objection right now to the answers that were contained in this Martin's
Not unless somebody
discovery
proves
response,
something.
unless somebody's planning on using them, and then I'll just make those objections.
let me, and maybe this will clarify, that the public record, no findings of fact are based on the public record.
Right, that
They're
was,
only, if one of the discovery questions comes up in terms of cross-examination,
Right.
and someone moves for it to become part of the evidentiary record, at that point, then it would move out of the administrative public file into the evidentiary record, and you treat it as if you would treat any other piece of evidence.
correct.
And a party can't move their own answers
Correct.
into the record.
There's some things that still spill over from the
There
rules
you
of
go.
procedure, which is nice.
30 minutes in and we're on procedure, we haven't stopped it here.
Okay, so that should take care of that, and we can go back on the record then?
Thank
Okay,
you.
Excellent, no, thank you. Okay, so we're back on the record, and I believe, Mr. Carpenter, your witness is going to be first to me?
Yeah, I don't know how you want to do this protocol-wise, but I'll just read the exhibits into evidence at this point that were submitted with the record, which I will be submitting in hard copy form to the court, through the board.
Well, you know what, why don't we swear in the witness first, and because at a certain point, I'm sure you're going to want to ask the witness to identify themselves and verify that these materials are, so, if you could.
And I will give copies of what we do have, which is basically the exact same document, just without the initial exhibit marks that were on the ones that were submitted to the board. Does that make sense?
Can we go for that? Those are exactly the same as the exhibits you would submit, but for lacking that one marking.
Yeah, well, yeah, but for the,
But they can just get exhibit labels by the clerk or then go in.
Yeah,
You
that's
have
what I
the
was
copies
thinking.
you need.
well, I have the copies we need of, excuse me, of these, we didn't have an affidavit attached to them. I might as well just give,
It doesn't need, the affidavit doesn't need to go
Don't
in,
need
just
the
the
affidavit
actual
since he's here.
exhibits. He's here.
yeah, no,
Just the
No,
exhibits.
because- Yeah, if you put the label on, and I have a copy of that
All right.
myself, so if the copy you were gonna give to me, you can just
And we have
admit,
copies here too.
and that would save everybody a lot of trouble.
okay, that's fine then.
Then you can just do the list and get the label
So let's start with those two then.
and the Westman and Cambridge, the two. The one is-
Do you have copies of our responses also for the 29th?
I have it all, I have our whole file here, yes.
I do as well. And Ms. Martin, do you have copies of the exhibits from the petitioner and also the letter, I think it was June 29th letter? Do you have copies of those, or do you need those?
The June 29th letter?
I think it was June 29th.
Yes, it was.
That is basically the reply comments.
The reply comments? I believe I do have them with me, but I have notes on them, so they're not.
Those are just yours to
Just
keep.
as long as you can refer to them.
Oh,
so that
sure.
if someone says, for example,
On page.
on page 5, you said X, Y, and Z, you can follow along.
Okay.
And make sure that.
Yeah, I've got copies of that.
says.
I realize the one exhibit I don't have is the Cambridge landscaping plan that was submitted.
That was part of your 629 filing?
That was a separate, yeah, that was a separate 629 filing.
It's the vegetative plan, correct?
Mhm.
For Mr. Wilbur's property. I think I have that as.
So, Mr. Carpenter, like this one, it's Cambridge 4A, but it's got these others behind it. Are they all part of 4A, or do they need to be merged?
Here's the list. I apologize.